Have a listen to this. Name the Australian nursery rhyme this riff has been based on, as well as the name of the man playing it.
When Adam Mills, the host of music quiz show Spicks and Specks, read out that question, little did he know he was about to trigger one of the most notorious music copyright cases in the history of Australian music. The song they played on the TV game show was Down Under by Men at Work, and the question of what children's nursery rhyme had been adapted for a riff in the song went far beyond trivia. Usually trivia questions are based on little-known facts. Well, this was far from a settled fact, and was so little known seemingly only the keen-eared researcher at the ABC TV show knew about it. Down Under was originally recorded nearly 30 years earlier, and was one of the biggest hits to ever come out of Australia. Yet for 3 decades, nobody noticed the alleged similarity to a much-loved Australian children's song. The song was written by Men at Work's lead singer and guitarist Colin Hay. He was born in Scotland and his family moved to Melbourne, Australia in 1967 when he was 13. He met Ron Stryker in 1978 and initially they formed a duo, but over the next year they grew to the 5-piece band that would eventually record their biggest hits. In 1979, having established themselves on the Australian pub rock scene, the band felt the next step was to record a single. With no record deal, they decided to fund the recording and release themselves, and founded their own record label called MAW. Released in 1980, the A-side of the single was called Key Punch Operator, and the B-side was Down Under. Both songs were written by Colin Hay and Ron Stryker, and were among the songs they regularly played live. The self-released single didn't make the charts, but along with their growing reputation as a live band, was enough to get the attention of record labels. They were discovered by the head of A&R at CBS, Peter Carpin, a Melbourne-born music executive who'd just spent the last few years working at the CBS office in New York, and he returned to Australia with a good ear for a global hit. They released their first song on CBS in June 1981. Who Can It Be Now went to number 2 and remained on the chart for the rest of the year. The follow-up single, released in October 1981, with Who Can It Be Now still on the charts, was a re-recorded version of Down Under, rearranged and shortened to be more radio-friendly. The changes worked and the song went to number 1 on the charts, where it stayed for 6 weeks. The album, Business As Usual, was also released in October 1981 and went to number 1 on the album charts, holding the top spot for 9 weeks. By February 1982, both Down Under and the LP Business As Usual had also reached number 1 in New Zealand, making it the first Australian album to be number 1 on the charts there. Despite its success for the Australian label, the parent company in America declined to release the album in the USA or the UK. However, the band's manager, a friend of Colin Hay's from university, contacted Peter Carpin, who used his connections at the New York office to make sure the album had an international release. In April 1982, Who Can It Be Now was released in the USA and the UK. In October, it reached number 1 on the Billboard Hot 100, and the following month the album began a 15-week run at the top of the album charts. Down Under entered the Hot 100 at number 79 and took just 10 weeks to climb to number 1. It entered the UK charts at number 38 and 4 weeks later was number 1. By the end of January 1983, Men at Work simultaneously had the number 1 single and album in both the USA and the UK, the first Australian act to ever achieve this. Since its release, the single and the album containing it have sold well over 13 million copies worldwide. The song has been used in adverts and movies, sung at sports events and adopted by sports teams. It was ranked number 2 on Australian rock radio station Triple M's Best Australian Songs of All Time list. And in 2001, Australasian Performing Rights Association, APRA, listed it as the 4th greatest Australian song of all time. So when Adam Mills read out the question on Spicks and Specks, you can understand the surprise and confusion not only the celebrity guest contestants felt, but also the audience watching at home, as it dawned on them that this beloved Australian hit song had allegedly taken a riff from a well-known children's song.
It's Men at Work.
Men at Work Down Under.
Greg Ham is the flautist.
Greg Ham of Men at Work, yes.
And Down Under is...
No.
We don't know that.
That riff has been based on a nursery rhyme. All right, I'll give you one more listen to it. This bit especially.
Oh my God.
Kookaburra sitting in the old gum tree?
That's exactly right.
Kookaburra Sits in the Old Gum Tree was written in 1932 by Marion Sinclair, a music and drama teacher at Toorak College in Melbourne, Australia. She said the song came to her one Sunday morning while at church and she dashed home to write it down. A few years later, she entered the song in a competition organised by the Girl Guides Association of Victoria, who were looking for a typically Australian round to be sung at Scouts and Guide jamborees. Her entry won and was sung at the first Pan-Pacific Jamboree held in Frankston from December 27, 1934 to January 13, 1935. It was the first international gathering of the organisation held outside of the UK and was attended by over 12,000 Cubs, Scouts and Guides from all over the world, as well as 62,000 public spectators. Kookaburra Sits in the Old Gum Tree, along with two other songs also composed by Marion Sinclair, was printed and distributed among the attendees. As a result, the song spread around the world and became a campfire favourite.
Kookaburra sits in the old gum tree, Mary, Mary, king of the bush and sea. Laugh, Kookaburra, gay, your life must be.
As per the rules of the competition, Marion Sinclair received prize money of 10 and 6, 10 shillings and sixpence, which is worth about $60 Australian in today's money. According to her entry in the Australian Dictionary of Biography, Marion Sinclair never charged any scout or guide group for printing her song. Although she expressed the honour she felt to have her song chosen by the Girl Guides, she had other poems and songs she had published that she took more pride in, although none of them really brought any significant financial reward. When she died in 1988, she left much of her money and assets to charity, and the South Australian Public Trustee were responsible for administering her estate. This included her copyright works, which under Australian law at the time would remain in copyright for 50 years after her death. In 2004, this was increased to 70 years, meaning all of Marion Sinclair's works would remain in copyright until 2058. The copyright to Kookaburra was eventually sold to Larrikin Music Publishing, a publishing company founded by cultural historian and folklorist Warren Fahey, with the aim of commercially releasing Australian traditional folk music. The new owners would be entitled to all revenue from the composition while it remained protected, such as this use of the song in an episode of Doctor Who from 2006.
Kookaburra sits in the old gum tree, Mary, Mary, king of the bush, you see. Love, Kookaburra, love, Kookaburra, gay, your life must be.
Shortly after the episode of Spicks and Specks aired in September 2007, Larrikin Music Publishing began receiving calls and emails, alerting them to the alleged infringement of the song. The decision to sue the creators of Down Under was made by Norm Lurie, who was then the managing director of music sales, Larrikin's parent company. In November 2008, legal proceedings began. The lawsuit alleged that the 1979 recording of Down Under, self-released by the band, the 1981 recording made under their contract with CBS, and two Qantas ads that contained an instrumental version of the song.
When Qantas started flying 87 years ago, we had big hopes for our future.
All infringed on the copyright of Kookaburra by copying a substantial part of the original song. But it wasn't just Australian copyright law they were accused of breaking. The Larrikin lawsuit also cited the Trade Practices Act of 1974, claiming that EMI, the band's publisher, knowingly made false claims to collecting societies such as APRA that they were entitled to 100% of the revenue from Down Under. The first step of the process was to establish ownership of Kookaburra. If Larrikin did not own the composition, they wouldn't be able to proceed with legal action. The legal team representing EMI and Men at Work disputed their claims to ownership, saying that the Girl Guides Association owned the song, citing a section from the terms of the contest. all matter entered to become the property of the Guides Association. However, this was ruled not to be enough to constitute a transfer of copyright, and that the copyright had remained with Marion Sinclair after winning the competition. This is because the clause spoke of matter, understood to mean something physical, rather than something intangible, like copyright. Sinclair's entry in a dictionary biography was also cited, with the reasoning being that if she never charged anybody to reproduce the work, then it doesn't need the protection of copyright. Larrikin were able to produce evidence that refuted the claim made in the book. There was a letter dated October 2nd, 1934 from the Girl Guide Association to Marion Sinclair, thanking her for paying to have Kookaburra printed, along with 2 other songs, and then selling those copies and donating the proceeds to the Guides. This showed that the Guides viewed the song as being owned and controlled by the writer, and considered the proceeds from the sale of Kookaburra to be a donation. Another letter, this time from September 1935, informed Sinclair she was to receive another 13 shillings and 7 pence from the Guides Association for sales of the song, and that they would continue to sell copies to other guide groups. In 1955, Jane Tobbett of the Guides Association in the USA sent Marion letters stating, "I could not find any authorization to reprint your charming round Kookaburra, which we've been using for years. It's the one permission I cannot trace. I'm greatly disturbed about it." This further proved there was no claim of ownership from the Guides Association, who still sought permission from the writer. These requests for permission to use the song were responded to by Sinclair, with instructions that any use of the song should carry acknowledgement of her copyright. Shortly before Marion Sinclair died, she gave a large collection of works to the State Library of South Australia. This included photographs and handwritten poems and songs. Among them was an arrangement of Kookaburra for violin. In a letter accompanying the donation, she stated, "Any copyright owned by me and the items listed shall vest in the board on my death." When she died, she left half her estate to the Animal Welfare Trust and the other half to the care home she spent her last days. The public trustee of South Australia was responsible for selling her assets and giving the proceeds to the 2 charities. In 1989, the public trustee auctioned the rights to Kookaburra. The winning bid came from Larrikin Music, who bid $6,100. However, as the library were in possession of the manuscript of Kookaburra and the letter stating they were being given the copyright in the work she had donated, they believed the copyright was theirs and initially disputed the sale to Larrikin. Eventually, the 2 organisations came to an agreement that the sale to Larrikin was valid and the library's board received $10 to surrender their claim. A tri-party agreement was then signed by Larrikin, the public trustee, and the library's board. This ratified the arrangement. It's this document that enabled Larrikin to prove their ownership and move forward with the case against EMI and Men at Work. In Australian copyright law, much like UK copyright, a substantial part of the original work must have been copied. The entire melody for Kookaburra is just 4 bars long. The part that is alleged to have been copied is the first 2 bars, so half the song. Whether by qualitative or quantitative measures, it's hard to argue that isn't a substantial part of the original work. The next step is to compare the 2 works to see if there's objective similarity. This is the part of Down Under with the flute line alleged to have been derived from Kookaburra. And here's the melody of Kookaburra played on the flute for comparison. Now listen again to Down Under with the flute part isolated this time. As well as examining the works for similarities, there must also be causal connection between the 2 works, basically that one work caused the other. This is similar to the access requirement in UK and US copyright law, where copying is assumed if there's objective similarity and it can be proved that the alleged infringing party had access to the original work. As Greg Ham admitted, he knew the Kookaburra song well, and thinks he may even have performed it at school, and that this may have influenced the flute riff he played. EMI and the 2 songwriters did not dispute that this constituted a causal connection between the works. Much like UK and US copyright law, the copying doesn't need to be intentional to constitute an infringement. During the trial, Dr. Andrew Ford, a musicologist called by Larrikin Music, submitted 3 reports that compared the 2 pieces of music. He was also cross-examined by Richard Lancaster, the counsel for EMI Publishing. He was asked if the fact the songs were in different keys and at different tempos showed that Down Under was significantly different to Kookaburra. His answer was, the tune carries within its structure a kind of musical DNA which enables you to say, well, that's Kookaburra Sits in the Old Gum Tree, because the interrelationships of the pitches, rather than the actual specific name of the pitches, which is why you can transpose it into any key you like, and it will be recognisably the same. He then demonstrated this by playing Kookaburra various different ways on the piano, but each time recognisable as the same melody. Just like in all other copyright cases, both parties each called their own musicologist. Usually the opposing experts will offer contrasting opinions, but in this case, Martin Armiger, the musicologist called by EMI, agreed largely with Dr. Ford. He agreed that the flute line in Down Under contained parts that were objectively similar to the melody in Kookaburra. The point he disagreed on was that Kookaburra's melody formed an essential part of Down Under. His assertion was that the vocal chorus was the most memorable hook in that song. In Colin Hay's evidence, he stated that he'd written Down Under before Men at Work were formed, and that the guitar line he wrote contained no reference to Kookaburra, and as a result bears no similarity. It's only in the recording that the flute line was introduced by Greg Ham, who was asked to play something to add to the Australianness of the track. Ham described what he played in his own written statement as an Aussie cliché melody. It was brought up in the trial that at some gigs, from around 2002 onwards, Colin Hay would sing the words to Kookaburra over the flute line in Down Under. In response to that, he said that he'd become aware of the connection to Kookaburra around about that time, but couldn't remember how he came to know, or who told him. It was also noted that in the video to Down Under, Greg Ham is sitting in a tree while playing the flute line. When asked if this is a visual reference to the Kookaburra song, Hay replied that he didn't remember whose idea it was for him to be sitting in a tree and never questioned why. Another point raised was how long it took for anyone to notice the similarity. Around 27 years had passed between the first recording of Down Under and the episode of Spicks and Specks that kicked off the court case. Even on the quiz show, the contestants were baffled at first and needed to be directed to the specific section on a second listen. During the trial, both recordings of Down Under were played, along with the music video. Both Qantas ads were also played. After reviewing all the evidence, Justice Peter Jacobson delivered his ruling on the 4th of February 2010. It is my opinion that the 1979 recording and the 1981 recording of Down Under reproduce a substantial part of Kookaburra. However, I do not consider that the Qantas advertisements infringe the copyright in Kookaburra because they do not reproduce a substantial part of the work. Greg Ham wasn't called to give evidence and instead submitted a written statement. The judge commented on the failure to call him as a witness. It is trite to say that I can infer that his evidence would not have assisted the respondent's case, but it's also open to me to infer that Mr. Ham deliberately reproduced a part of Kookaburra, an iconic Australian melody, for the purpose and with the intention of evoking an Australian flavour in the flute riff. In conclusion, the judge wrote, I have come to the view that the 1979 recording and the 1981 recording of Down Under infringe Larrikin's copyright in Kookaburra because both of those recordings reproduce a substantial part of Kookaburra. I am also in the view that Larrikin is entitled to recover damages from the respondents for the infringements under the TPA, or the Fair Trading Act. Nevertheless, I would emphasise that the findings I have made do not amount to finding that the flute riff is a substantial part of Down Under, or that that is the hook of that song. Larrikin believed that they were entitled to between 40 and 60% of the earnings from Down Under as a result of the infringement. The judge disagreed and awarded them just 5% of composition royalties, with a limitation on backdating of 6 years. The only money they would receive from the recordings of the Men at Work song would be the mechanical copyright royalties, which meant the settlement was only worth around 100,000 Australian dollars. Meanwhile, Colin Hay was quoted as saying the legal bill for the case was around 4.5 million Australian dollars. Naturally, the verdict was appealed. EMI claimed that Judge Jacobson had applied the wrong principles in assessing substantial part in the context of copyright infringement of a musical work. Larrikin also lodged their own appeal, that disputed the ruling that the Qantas advertisements containing an orchestral version of part of Down Under, including a quotation of the second bar of Kookaburra, did not reproduce a substantial part of their song, and also disputing the trial judge's finding that the EMI companies were not liable for authorising an infringement of copyright by granting licences to third parties to reproduce Down Under in a number of works, including the Qantas ads. When it comes to an appeal, this isn't simply a do-over because you don't like the verdict. There has to be an error in the application or interpretation of legal processes, or the judge has to be plainly and obviously wrong. As a result, it's quite rare that appeal judges would entirely overturn the ruling of a trial judge. In this appeal, the judges were Arthur Emmett, Jane Jago, and John Nicholas. Justice Emmett found that it was at least arguable that the trial judge erred in his approach to assessing the reproduction of a substantial part, and as such it was open for the full court to reconsider the question of infringement afresh. On the other hand, Justice Jago did not find error with the trial judge's approach, and concluded that the full court should not disturb his findings with respect to copyright infringement. Justice Nicholas agreed. All three appeal judges accepted that while it was true that the similarity remained unnoticed for some 20-odd years, it was not wrong for the trial judge to compare the similarities between the melodies by listening to the tunes repeatedly, assisted by experts. The issue of when and by whom the infringement was first noticed was not itself relevant to the determination of objective similarity. The full court upheld the findings on authorisation in relation to the Qantas ads, accepting that they did not reproduce a substantial part of Kookaburra, so the claim of authorisation of copyright infringement by the Qantas ads could not be sustained. Justice Emmett made a statement expressing his view that the use of Kookaburra in Down Under is just one of the many tributes to Australian culture that appear in the song, such as the reference to a combi or a Vegemite sandwich, and the band drinking from blue beer cans, obviously a reference to Foster's Lager. If, as I have concluded, the relevant versions of Down Under involve an infringement of copyright many years after the death of Miss Sinclair and enforceable at the behest of an assignee, then some of the underlying concepts of modern copyright may require rethinking. He noted that the duration given for a patent is far shorter than the protection given to artistic works, such as songs. He questions if the people who wrote the first known copyright law, the Statute of Anne from 1710, would view the use of Kookaburra in Down Under to be an infringement, or just fair use. EMI requested special leave to take the appeal to the High Court, but on the 7th of October 2011 this was denied, finally bringing to end the 3-year case. Following the verdict, Larrikin's Norm Lurie said, "I think it's been a story of a small independent company standing up for our rights and not being pushed around by a company with very much deeper resources." EMI at the time had an annual global turnover of over $1 billion and over $50 million from the Australian subsidiary alone. They could easily afford the $4.5 million legal bill. But it wasn't just EMI they were suing. They also sued two individuals, Colin Hay and Ron Strikert, who, despite being successful musicians, did not have the deep pockets of their publisher and would certainly have been severely impacted financially by the case. The trial and the appeal created a major stir in Australia, with many people outraged that the copyright of a well-known Australian children's song was being used to make money from an iconic Australian band by someone other than the writer of the song. Many believed that either Kookaburra was public domain or it should be. The founder of Larrikin Music, Warren Fahey, came under fire for allowing the legal battle to happen, even though he'd sold the company in 1988, 20 years before the court case, and 2 years before Larrikin even owned the song. He made numerous public statements explaining he had no involvement whatsoever and opined that the new owners should drop the case and gift the song to the people, basically making it public domain. Greg Ham, who was named in the ruling as the one responsible for the infringement, took the verdict particularly hard, saying, "Terribly disappointed that that's the way I'm going to be remembered, for copying something." As well as the emotional stress, he was left financially ruined, forced to sell his house to cover legal costs, and he took a job teaching music to earn money. According to his friends and family, he descended into a deep depression, drinking heavily, and some reports say he developed a heroin habit. On April 19, 2012, Greg Ham was found dead at his home in Melbourne.
Police were called to the Carlton North home around lunchtime after a friend of Greg Ham's raised the alarm.
He attended here, he couldn't get anybody to answer the door. He went away, returned with another person, and they located him inside the premises.
Police say there are a number of unexplained circumstances about the death.
We've got forensic crime scene specialist in attendance, and the pathologist will be attending at a later time, then conducting a subsequent post-mortem examination. Those forensic resources will help us to determine what has occurred and what is the cause of death.
The official cause of death was eventually listed as heart attack. However, many people, Colin Hay included, believe the court case was at the very least a contributory factor to his death, if not a direct cause. In November 2021, Down Under was back on the charts. This time it was a remix by Australian drum and bass producer Lurie. The track was originally made available just on social media, but after hearing the new version and loving it, Colin Hay agreed to re-record the vocals. The Lurie single featuring Colin Hay made the top 10 in both Australia and the UK and went to #1 in New Zealand. Now, what do you think? Let me know in the comments, and be sure to subscribe and turn on notifications to get all the latest videos.